Tantor Audio, a division of Recorded Books, presents Roe v. Dobbs, The Past, Present, and Future of a Constitutional Right to Abortion. Edited by Lee C. Bollinger and Geoffrey R. Stone. Narrated by Malcolm Hillgartner. Opening Dialogue. Lee C. Bollinger and Geoffrey R. Stone. Bollinger. This is our sixth project working together on major constitutional issues. Our driving philosophy has been, and remains, that a combination of voices from leading experts, including our own, along with focused recommendations on some of the nation's most significant contemporary issues, and typically at historic judicial anniversaries, will yield a useful overview for experts and non-experts alike, and welcome insights and contributions toward answering or resolving the questions at hand. In 2002, Eternally Vigilant, Free Speech in the Modern Era, launched our ambitions for reflecting on the principles of freedom of speech and press at the turn of the new century. The Free Speech Century in 2019 was a similar effort to mark the 100th anniversary of the first Supreme Court cases interpreting the First Amendment's words, "Congress shall make no law abridging the freedom of speech or of the press." This was followed on the 50th anniversary of the Pentagon Papers decision in 2021 by National Security, Leaks, and Freedom of the Press, the Pentagon Papers 50 years on. More recently, we took on the vexing issues of regulation, or not, of bad speech on the Internet and social media platforms in Social Media, Freedom of Speech, and the Future of Our Democracy, 2022. And earlier this year, we published our own views on the constitutionality of affirmative action policies in higher education in A Legacy of Discrimination, the Essential Constitutionality of Affirmative Action. Now, with this volume, Roe v. Dobbs, The Past, Present, and Future of a Constitutional Right to Abortion, we confront the remarkable beginning and end, once again, after a half-century, of the landmark Supreme Court decision in Roe v. Wade, stunningly overruled by the court in Dobbs v. Jackson Women's Health Organization. What makes this subject unique among our collaborations is how it intersects with our own lives, since both of us were law clerks in the year Roe was decided, 1973, you for Associate Justice William Brennan, and me for Chief Justice Warren Burger. So let's start there. I would add that you have also written extensively and deeply about Roe, its context, and the inner workings of the court that produced this remarkable decision. Your book, Sex and the Constitution, Sex, Religion, and Law from America's Origins to the 21st Century, provides the best description and analysis of the pre-Roe, Roe, and post-Roe worlds that I know of. Can you lay out your observations, starting with Roe, and how we got there? Stone. As always, Lee, you're much too kind. But instead of dwelling on that, let me turn to the substance. During the court's 1972-73 term, when Roe was decided, the court was in a state of flux. President Nixon had just appointed 4 justices to the court: Burger, Blackmun, Powell, and Rehnquist. The era of the Warren Court was clearly over. Yet although these justices were clearly thought to be conservative at the time, they were not nearly as conservative as, pardon the expression, the extremely right-wing Republican-appointed majority on the current court. In those days, the justices were nonpartisan, often joined opinions across the political ideological spectrum, and approached most cases with an open mind. That in large part explains why the court could reach the decision it did in Roe, with 5 of the 6 Republican-appointed justices and 2 of the 3 Democratic-appointed justices in the majority, and 1 Republican-appointed justice, Rehnquist, and 1 Democrat-appointed justice, White, in dissent. It was a different court and a different era. But what led the justices to vote 7-2 in Roe to recognize a constitutional right of women to terminate an unwanted pregnancy? In my recollection, at least 2 factors opened the justices' minds to such a decision. First, until the late 1960s, almost everyone assumed that abortion had been illegal from the beginning of Western history. But as the women's rights movement gained steam, and justices, especially Justice Harry Blackmun, who wrote the majority opinion in Roe, looked into the history, this turned out to be completely wrong. To the contrary, abortion had been legal, at least up to the midpoint of pregnancy, throughout Western history, from the ancient Greeks to the Romans to the Middle Ages, in England in the years leading up to the American Revolution, in the American colonies, and in all the states at the time the Constitution was adopted. Indeed, it was not until the mid-19th century that abortion in America began to be criminalized, and what became clear was that the primary driving force for this movement was a combination of religion and disdain for the interests of women. Thus, by the end of the 19th century, every state in the nation had made abortion a crime. Nonetheless, by the beginning of the 20th century, some 2 million women each year resorted to illegal abortions, which were often terrifying and dangerous. For most of the justices, knowledge of this history was both mind-opening and powerful. Second, until the late 1960s, almost all Americans assumed that illegal abortions were rare. The reason for this was that abortion was illegal, and women who had abortions could not tell anyone, except perhaps close friends and some family members, what they had done. Not only was abortion illegal, but for the past century, most Americans had been led to believe that it was profoundly immoral. Thus, it was seen as essential for women to not say anything. As a result, most people had no idea how many illegal abortions were being performed or how dangerous these illegal abortions were. Once again, as the women's movement gained steam in the late 1960s, these facts were increasingly made public. As we learned at the time, approximately 1 million women each year still had illegal abortions, many of them either self-induced with the use of coat hangers and similar objects, and many others through back-alley abortions, which were often performed by people the woman didn't know, couldn't see, and who had little or no training. As these facts came to light, both the horrible consequences of making abortion illegal and the often desperate need for women not to have unwanted babies, as evidenced by their extraordinary willingness to resort to dangerous, unlawful abortions, clearly affected both the nation and the justices. With these two understandings in mind, the justices, or at least 7 of them, both conservatives and liberals, came to understand that denial to women of the right to terminate unwanted pregnancies was a profound and fundamental violation of women's right to make these decisions for themselves, and to be able to do so in much safer environments with the assistance of trained professionals. Anyway, that's my sense of what motivated the justices to understand that the right recognized in Roe was both essential and warranted by our Constitution. Bollinger. These points, that the decision in Roe crossed judicial ideological lines at the time, and that the decision was the result of a growing realization about the relatively recent and extraordinarily injurious impact of bans on abortions and intimate decisions by women and their physicians, are well put. I would add 2 additional observations, and then ask a question. First, it seems important to understand that, while Roe unquestionably was an important decision of that Supreme Court term, it was not regarded either within the court or by the general public as the most important or controversial decision of the period, nor was it regarded as a radical expansion of constitutional rights. Certainly, nothing like how it came to be portrayed by the conservative establishment over succeeding decades. How and why that happened is one of the most important questions for this book. Indeed, the primary focus of that year was on the well-known intention of the newly appointed conservative justices to curtail First Amendment protections for speech deemed obscene. The Nixon appointees, led by Chief Justice Burger, wanted to allow greater latitude by local communities to prohibit erotic speech, believing that this was needed and justified to preserve the moral character of society. They achieved this aim with narrow majorities in 2 very prominent cases, Miller v. California and Paris Adult Theater v. Slayton, which together provided a new and fundamental governing standard for how to treat obscenity under the First Amendment. That raises the second point I would make about Roe, focusing now on its purported rationale. Here, too, the comparison with Miller and Paris Adult Theater is interesting, but in another way. Both the obscenity decisions and Roe offered justifications that were challenged, expanded, and supplanted in the years to come by the women's rights movement in America. As you know so well, Blackmun's opinion in Roe emphasized a combination of interests supporting recognition of a right to an abortion, the woman's right, to be sure, but also that of her treating physician. The latter seems to have arisen from Blackmun's prior long relationship with the medical community, most significantly by serving for many years as the general counsel of the Mayo Clinic. The woman's interest was also present, but not anywhere close to the degree that many came to understand as the reality of systemic discrimination. So Blackmun's comments about distress experienced by women in having to carry a pregnancy to birth and beyond was arguably weaker than the claim that women must have a right to control their reproductive lives in order to be fully equal citizens in society. Similarly, but even more forcefully, this same transition in sensitivity to the interests of women transformed the debate about the regulation of obscenity. Within a few years of Miller and Paris adult theater, the argument shifted from respecting the state's interest in preserving the moral character of the community to protecting women from discrimination in the production and distribution of pornography. That leads, then, to my question. Do you think it would have made a difference over time if Roe had been grounded not simply or primarily in a right of privacy, but in a more fully dimensional understanding of the often intentional and discriminatory consequences of laws banning abortions? It is worth noting here that you and I have argued, in the context of the constitutionality of affirmative action, that it was highly unfortunate that the court in 1978 abandoned the original rationale for affirmative action that was based on the value of achieving racial justice, and instead embraced the much weaker rationale of the interests of higher education in achieving the benefits of educational diversity. Let me just quickly add that many others have made the point I'm making here, so I don't for a second present it as an original insight. Nevertheless, we experienced the origins of Roe and its thinking, and the changes in public values and debates that followed, and perhaps we can offer some perspective on how this area of constitutional law and political debate evolved or might have evolved. We also need to discuss the theories of constitutional interpretation that are implicated and came to be symbolized by the Roe decision. Stone. You raise an interesting question. Why did Justice Blackmun rest the decision in Roe on the woman's right of privacy rather than on the reality that laws prohibiting abortion unconstitutionally discriminated against women? I can offer three possible explanations. First, in important cases, and for obvious reasons, the justice writing the majority opinion wants as many of the justices as possible to sign on to that opinion. Thus, in such cases, the justice writing the majority opinion often must try to find common ground, even though some of the justices might prefer a different approach. Justice Blackmun was certainly faced with that challenge in Roe. Second, Blackmun's invocation of a woman's right of privacy with respect to such fundamental decisions as whether to bear or beget a child was grounded in several important prior decisions of the court. At the outset, it should be noted that the Ninth Amendment clearly recognizes that there are constitutional rights beyond those expressly spelled out in other provisions of the Constitution, such as the freedom of speech, the freedom from unreasonable searches and seizures, and the freedom of religion. Indeed, the Ninth Amendment expressly provides that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Thus, in a number of important decisions going all the way back to 1925, such as Meyer v. Nebraska and Pierce v. Society of Sisters, as well as Griswold v. Connecticut in 1965, the court had recognized that an unenumerated but fundamental constitutional right to privacy protected such fundamental personal freedoms as the right to decide how to educate one's children and the right to decide whether to use contraceptives. I should note that privacy in this context does not mean secrecy, but the right to make fundamental personal decisions for oneself. Third, Why didn't Blackmun focus expressly on the constitutional right of women not to be discriminated against or specifically disadvantaged? After all, it was a common phrase in the late 19th century that if men could get pregnant, abortion would be legal. And that no doubt was true. But did the 14th Amendment's Equal Protection Clause prohibit laws that discriminate against women? According to the Supreme Court, until just a few years before Roe, the court said no. Such laws, the court held, were constitutional as long as they were rational. Thus, for example, in Bradwell v. Illinois, the court held in 1872 that state laws prohibiting women from being lawyers were constitutional. As one justice explained, such laws did not violate the Equal Protection Clause because the paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. Only 2 years later, in Minor v. Happersett, the court unanimously held that, although women are no less citizens than men, state laws that ban women from voting are constitutionally valid. Moving closer to the present, in Gosert v. Cleary in 1948, the court upheld the constitutionality of a law prohibiting women from serving as bartenders because the state could rationally conclude that bartending could create moral and social problems for women. Indeed, the court did not hold unconstitutional a law that expressly discriminated against women until 1971, in Reed v. Reed, in which the court held that a state statute providing that males must be preferred to females in estate administration was irrational and therefore violated the Equal Protection Clause. But the fundamental question remained whether laws that discriminate against women should be deemed unconstitutional under the Equal Protection Clause unless the laws survive strict scrutiny rather than rational basis review. Why didn't the court embrace that theory in Roe? For those of us who were inside the court at that time, the answer was clear. In Frontiero v. Richardson, a case decided during the same term as Roe, the justices considered the constitutionality of a military policy that automatically gave benefits to the wives of male soldiers, but gave them to the husbands of female soldiers only if the husband was dependent on his wife for more than half of his support. 8 of the 9 justices, all but Rehnquist, voted to hold the law unconstitutional, but only 4 of them, in an opinion by Justice Brennan, concluded that laws that discriminate against women are consistent with the Equal Protection Clause only if they satisfy the strict scrutiny test, which this law clearly did not. The 4 other justices in the majority, however, refused to address the strict scrutiny issue, instead rather disingenuously arguing that the law was irrational, even though it wasn't. They did this because the Equal Rights Amendment had been sent to the states for ratification in 1972, and they believed that it would be inappropriate for the court to interpret the Equal Protection Clause in a way that would effectively render the Equal Rights Amendment redundant. It was for that reason that the justices in Roe could not muster the votes to strike down abortion laws on equal protection grounds, even though 7 of the justices agreed that it was unconstitutional for states to deny women the right to terminate unwanted pregnancies on right-to-privacy grounds. Bollinger. Roe may have crossed ideological lines when it was decided in 1973, and at the time it seemed to most legal experts as a natural step in the evolution of core fundamental rights, even among those that were unenumerated in the constitutional text. Moreover, as you noted earlier, it was received across the nation as a basically sound and reasonable result. But 2 things happened in the coming decades. One was an increased appreciation of the decision as our collective sensibilities about the rights of women developed, and the other was a demonization of the decision among the new and growing conservative segments of American legal and political life for the court's purported abuse of judicial power with respect to the interpretation of the Constitution. The latter forces finally triumphed with the decision in Dobbs. At the heart of the debate about abortion, then, is the fundamental question: how do we interpret the Constitution? At this point, everyone accepts that the Constitution protects certain rights of citizens against infringement by the state, and that the role of the courts is to articulate those rights. We recognize, too, that the text itself is extremely brief and general. Congress shall make no law abridging the freedom of speech, barely providing a guide. What constitutes the freedom of speech? Are all actions that communicate encompassed by the freedom of speech? What conditions necessary for the freedom of speech are protected? Expenditures of money, a decent education, and, as you say, the Ninth Amendment specifically and explicitly charges us to protect rights that are not expressly enumerated in the text of the Constitution. Thus, with respect to every single right recognized by the court over the decades and centuries, there are extensive, sometimes labyrinthine doctrines, analytical formulations, and decisions in concrete cases that altogether provide the foundation for those rights. And there can be no doubt for any reasonable person that those collective decisions undergirding every single right go far beyond what the framers thought about the Bill of Rights in 1789. Indeed, given the vagueness and brevity of the document they drafted and adopted, the only reasonable conclusion is that they intended it to evolve over time, which of course is exactly what has happened in every court, in every period of American history. That said, it is also vitally important that the Constitution not serve as a contentless charter for justices to implement their personal or political preferences under the guise of doing law. That, too, would be as bad as setting constitutional rights in some sort of 18th century amber, which would also essentially be an invented reality. This is the dilemma of constitutionalism, and a profoundly serious one. Roe v. Wade came to symbolize this problem, and that is what we are struggling with throughout this volume. There is a natural wish in all of us to find simple answers for hard problems. You and I and every author in this book believe that there is something real in the process of constitutional interpretation that, while extremely difficult, perhaps even impossible, to articulate, nevertheless is different from making political judgments and is worthy of respect in a democracy. It is not a process captured by fictional notions of original intent, and not one frozen in a distant past, when our notions of right and wrong, fair and unfair, just and unjust, may well have been, from our current vantage point, embedded in error. A good-faith constitutional interpretation works like any good relationship, informed by knowledge of constitutional law and law more generally, sincere and genuine respect for the efforts of others to know and to discover the law, demonstrated actions of deciding against one's own likes and dislikes, and a sense of caring and patriotism for the nation. Roe and Dobbs highlight these issues. Stone. This leads me to a couple of final observations. First, in light of the complications of constitutional interpretation that you identify so well, one might sensibly ask why our Constitution even has a Bill of Rights, and why we should trust the justices of the Supreme Court to give the Constitution's often vague and open-ended terms meaning. It's worth remembering that when the Constitution was first drafted, James Madison, perhaps the most important of the framers, did not believe a Bill of Rights would serve any purpose. He believed that political majorities would interpret those rights in any way that suited their own self-interest, and that guaranteeing such rights in the Constitution would therefore lead only to cynicism and disillusion. On December 20th, 1787, though, Thomas Jefferson wrote to Madison from Paris that, after reviewing the proposed Constitution, he regretted the omission of a Bill of Rights. In response, Madison expressed his doubt that a Bill of Rights would provide any meaningful check on the passions and interests of popular majorities. He maintained that, in practical effect, such constitutional guarantees would be mere parchment barriers. What use, he asked Jefferson, can a Bill of Rights serve in popular governments? Jefferson's answer was clear. The courts, he said, will make sure that the Bill of Rights is effective. Your thoughts on the subject of the Declaration of Rights, he told Madison, failed to address one consideration which has great weight with me, the legal check which it puts into the hands of the judiciary. This is a body which, if rendered independent, merits great confidence for their learning and integrity. This exchange apparently helped persuade Madison. On June 8, 1789, Madison proposed a Bill of Rights to the House of Representatives. Echoing Jefferson's letter, Madison said that if these rights are incorporated into the Constitution, independent tribunals of justice will consider themselves the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. They will be naturally led to resist every encroachment upon rights guaranteed in the Constitution. It is this special responsibility for making our constitutional rights a reality, rather than, in Madison's words, a mere parchment barrier, that should animate the court's approach to constitutional interpretation. But what does that mean? In my view, and in the views of many, this means that we should distrust democracy in certain contexts, and that we need to rely upon the courts to protect the relatively powerless against both hostile and indifferent majoritarian abuse. This suggests at least two contexts in which courts should be especially active in protecting our most fundamental values. The first of these involves the electoral process. If majorities have a free hand to structure that process in any way they see fit, they will inevitably do so in a way that guarantees their continued control of government. The second, and the context especially relevant to the abortion issue, concerns the tendency of those in control of the democratic process to disregard the fundamental rights, whether freedom of speech, freedom of religion, freedom from unreasonable searches and seizures, or the right to equal treatment, of those not in control of the government. It is, in this sense, that the gendered element of the abortion right comes into play. As I noted earlier, if men could get pregnant, abortion would be safe and legal. And with that, I suggest we turn the floor over to our many distinguished authors who will provide a broad range of views on these and other issues. Part 1. The Supreme Court. Roe v. Dobbs. 1. Liberal critics of Roe. David A. Strauss. In the decades before Roe v. Wade, the Supreme Court was the subject of intense partisan and ideological conflict. The Warren Court, beginning at least with Brown v. Board of Education in 1954, was bitterly attacked for judicial activism, exemplified supposedly by its decisions expanding the rights of criminal defendants, prohibiting state-sponsored prayer in public schools, and, in cases like Brown, trying to uproot Jim Crow segregation. Richard Nixon's successful presidential campaign in 1968 prominently featured attacks on the Warren Court. Against that background, it's natural to think that Roe v. Wade, decided on January 1973, less than 4 years after Chief Justice Warren's retirement, was simply a continuation of Warren-era conflicts between liberals who were identifying new constitutional rights and conservatives who were trying to preserve the status quo. But that is not an accurate account either of the political reaction to Roe or of the relationship between Roe and the controversies that surrounded the Warren Court. Roe was a thoroughly bipartisan decision, and it scrambled Warren-era ideological lines. Of the 7 members of the Roe majority, 5 had been appointed by Republican presidents. 3 of the 7, enough to reverse the outcome, were appointed by Nixon, who had vowed that his appointments would change the direction of the court from what it had been in the Warren era. Those 3 included Justice Harry Blackmun, the author of the opinion in Roe, and its most passionate defender among the justices. One of the 2 dissenters in Roe, Justice Byron White, had been appointed by a Democratic president, John Kennedy, and was often aligned with the Warren Court majority. Roe was decided less than 2 years after the deaths of 2 of the central figures of the Warren Court. Had they still been on the court, it would have been even more obvious how Roe crossed partisan and ideological lines. Justice John Marshall Harlan was the Warren Court's most prominent dissenter, but he can fairly be called the godfather of Roe v. Wade. He had advocated a constitutional right to reproductive freedom since 1961. Justice Hugo Black had been an intellectual leader on the Warren Court.
Sample complete. Ready to continue?